Erin, you have been working on this issue for a while. Just take us through the FACE Act, what it is, why now we've reached a tipping point, and what can be done to fix what I and many others consider to be a grave injustice.
Absolutely. So as you mentioned, the FACE Act was passed under President Clinton. It was a law that was intended to protect reproductive facilities from intimidation and violence. And Congress was really specific. They defined those facilities as not only covering things like Planned Parenthood, but also covering pregnancy centers, pregnancy resource centers, as well as churches, protecting them from intimidation and violence. But fast forward to the Biden administration, and since 2021, the Biden administration has prosecuted 55 individuals under the FACE Act. 50 of them were pro-life. It's instituted 24 cases under the FACE Act, only 2 of them very belatedly against violence directed at pregnancy care centers. And it hasn't lifted a finger to protect churches. It is absolutely a violation of the rule of law, the way the FACE Act has been enforced by the Biden administration.
It just seems so obvious that the law was a fraud. You mentioned belatedly, okay, they're going to throw a few crumbs at the pregnancy centers, but the way they got the law through was to say this is going to protect pro-lifers and it's going to protect churches and all these, and that was just a lie. This has been used to protect abortion mills from criticism and broadly, mostly peaceful protest, to use a phrase that became popular in recent years. So you mentioned these cases that have been brought against the pro-lifers. Who are they? How long are they going to be in jail for? What justice is coming to them?
Absolutely. Well, one of the ways the Biden administration has further weaponized the FACE Act is for the first time ever, they've tacked on a conspiracy to violate rights charge. And that means individuals like Eva Edel. She is an 80-year-old concentration camp survivor who blocked an entrance, maybe not the best idea, but she peacefully blocked an entrance to an abortion clinic. That's all she did. In her wheelchair, concentration camp survivor, she could face 11 years in prison because they tacked on this conspiracy charge, again, for a completely peaceful protest.
I wonder if the claim here from the abortionists is that they can't be physically intimidated at their places of work. Was anyone ever physically intimidated by this concentration camp survivor in a wheelchair?
She just sat there in her wheelchair. I can't personally imagine being intimidated by an 80, I think she's 89-year-old concentration camp survivor in a wheelchair. I don't think that's very intimidating.
So, one, can President Trump pardon these people? Will he pardon these people? 2, what can be done as a permanent fix to this hideous law that is obviously just being weaponized to prosecute some of the best people in America on behalf of the worst people in America?
So absolutely. President Trump mentioned during the campaign that he was looking at pardoning a number of these individuals. Some of them have received 5-6 years in prison. Again, but the Biden administration is charging them with this conspiracy charge. So that gives them a lot of potential time in jail. So he can look at those cases. It would be fantastic. He's promised to do so and absolutely pardon them. Many of them have already served years in prison. And let's not forget, if there is some violence that happens, state assault laws, state trespass laws, state nuisance laws, all of those things apply. There's simply no reason to tack on the FACE Act, which has FBI agents showing up at the homes of mostly peaceful protesters or even peaceful protesters entirely, and really using the legal system to intimidate them. So I would submit that the FACE Act should be repealed by Congress.
I totally agree. In terms of the courts, is there anything that the courts can do here? I mean, the law just, even if it is not repealed, just seems to have been implemented so unfairly. It just seems like a fraud to me. Is there anything that judges can do?
There's 2 things. So if a person is charged with a FACE Act violation, the federal courts could look at that and say, in a exactly similar situation, a pro-abortion individual was not charged with a violation of the FACE Act. That's unconstitutional selective enforcement based on viewpoint. It should be disallowed, and a prosecution shouldn't be allowed to go forward on that basis. More broadly speaking, as you mentioned, there's fundamental problems with the FACE Act in that it is really intruding on state and local authority. We think of local authorities, for example, in Mr. Hook's case. Mark Hook was arrested in Pennsylvania. The local and state prosecutors had declined to prosecute because there wasn't anything going on there. And yet the FBI showed up at his door in front of his children, and he was charged with a federal FACE Act violation. The law intrudes into state and local prerogatives. It's suspect under the Commerce Clause. Congress is a government of limited powers, and so I think there are things the federal courts can and should consider doing.
Now, before I let you go, one case I want to talk about, Kara versus Planned Parenthood South Atlantic. A case regarding abortionists and Medicaid funds. What is the case? What are the stakes? What are the odds that we get a win for life?
So the stakes are really high. South Carolina determined that based on their safety record and other considerations, it was not going to allow Planned Parenthood to have state funds. It wasn't going to pay for abortions. It didn't want to do that. And so Planned Parenthood sues. And this gets kind of technical, but it's a key structural separation of powers issue. Under our Constitution, Congress gets to enact the law, and you can't have the federal courts coming in and saying anyone can sue regardless. So in the Medicaid statute, Congress provided an avenue for providers like Planned Parenthood to challenge these state determinations that they were not qualified to provide state care. But there's a system for that. It's not going through the federal courts initially. Instead, what the Court of Appeals and the lower court did in the Care case was create what's called a private right of action, where Planned Parenthood can go immediately to court. So two key issues here. One, do courts get to create private rights of action for plaintiffs they like? And two, was South Carolina appropriate in denying state funding to abortion providers?
How are we looking? Just as you say, look, it looks pretty good that President Trump will pardon the pro-lifers. If I were a gambling man, I'd say I think that's going to happen. How are we looking on this case?
I think pretty good. The fact that the Supreme Court granted cert in this case is a good sign. I'm not sure they're anxious to take an abortion case, but the technical issue here is one that the Supreme Court recently has been really firm on. This is Congress's job. It's not the federal court's job to create these private rights of action. So I'm very optimistic.
That's wonderful. Erin, I will make sure that, we look into exercising the technical equipment in the studio before the next time you are on. But keep up the marvelous work. Thank you so much for coming on the show.
Thanks for having me.